Welcome to the People's Law School. I'd like to give a special thanks to Mayor Tommy Battle and Judge Sonny Rodenhauser who allow us to be here. My name is John Brinkley. I'm a member of the Alabama Association for Justice and a member of the Alabama Criminal Defense Attorneys Association. It's my pleasure to introduce Brian Clark. He is a criminal defense attorney who practices all over the state of Alabama. His main office is here in Huntsville, Alabama, where he handles a host of cases, mainly dealing in some of the higher profile criminal crimes that you see here, which include some of the white-collar crimes, as well as the capital cases where the death penalty could be at stake. He handles those types of cases all the way down to a simple moving violation here in the municipal courts in Madison County. Early on in my career, I found that I had a lot of questions that I just really couldn't figure out the answer to, and I was very fortunate in that I ran across Brian Clark early on because I was able to ask him some of the things that had confused me, even dating back to law school. Brian Clark originally came from New York. He came to the state of Alabama where he became a teacher. And after being a teacher for some time over near the Quad Cities or in Moulton, he then went on to the University of Alabama Law School, and now he's practicing law here. Prior to practicing law here in Huntsville, he was in the military, and he did some military work. He and his wife Shannon, who's seated here with us, they have 3 children, and he'll tell you a little bit about them. But I want to tell you some of the things that I will find most interesting about Brian is he really does care about his clients. On occasion, I've seen him give out his cell phone number, which is miraculous in that line of work. He also teaches Sunday school every single weekend at his church with the children's ministry, which I find fascinating. The children have a little thing that they do at the end of the Sunday school where they all put their name tags on Mr. Bry. So I will tell you that it's my pleasure to introduce Brian Clark here, and I look forward to hearing what he has to say.
Thank you, John. Appreciate it. Thank you all. Nice welcome. I have a number of kids that, like John says, they like to put the stickers on me. I think it's about as many kids as John himself has. Now, that last account that he had 5, but I'm not sure because it's a fluid number that goes on next door. But it's great. We're neighbors, and our practices are next door. And even though I've got about maybe 3-4 times the number of years that he has, it's fun to bounce stuff off each other. And we do it in the morning. That's how our days start. We usually start with a cup of coffee. And you're all welcome if you come by and see us on the porch in the morning drinking coffee. Stop by if you got a question to ask. And only about $250 to $300 an hour, depending on how we feel. So come on in, enjoy it, and we'll start it. The bill, we just need a good address to bill it. But I love the practice of the law. It's just fascinating, and it's coming up on 23 years now. Yeah, well, actually just past 23 years in January. And Saturday I was over at Rolo's with a group of men, and one of them, and I just love it, it never gets old. He said, "Let me ask you this." He goes, "How do you do the criminal defense, though?" He's like, I mean, when you just absolutely know they're guilty. And it's funny, 23 years, and the question never gets old. How do you defend somebody that you know is guilty? And I said, that's easy. Defending the guilty people, that is so easy. They're guilty, you know they're guilty, and you're just making the state or the government, the U.S. government, do their job. The system's built on they have to meet their burden, prove the case beyond a reasonable doubt. I said, the really hard part is when my client's innocent, because then the system is entrusted in me to make the government do their job, and I've got somebody that did absolutely nothing wrong. And if I don't do my job, if everybody does their job, an innocent person go to jail. And I don't know if anybody here, and don't raise your hand, this is not a question I want you to ask you. If I go to the jail regularly, and I'm down there for an hour or 2, it's horrible. It is horrible, horrible place to be. And I have people that, I'd say one of them about 2 years ago, they offered my client 9 years. And John knows this case by kittens. And they offered him 9 years. My client said, can't do it. And we turned it down, we went to trial, and we won the trial. And I'll say this, I won't get into the whole aspect of guilt or innocence, but on my watch, he didn't spend a day in jail based on my case. And that's an important thing. So, like I said, innocence, an innocent client, those will keep you awake all night long. And so, like I said, guilty clients, easy to defend. If you lose, they're just going to get what they pretty much deserve. I've had very few clients in 23 years that have gotten a day more than they deserved in prison. But an innocent person in your hands, that will keep you awake. If you ask my wife, I get about probably 1 or 2 nights a month of sleep, of good sleep. And go talk to my doctor if you want to know what it's like to be a criminal defense attorney. It'll mess up your sleep rhythms. The other thing, and it's funny, one of my old friends from law school, he became a defense attorney before me. And this is what I loved, and I learned early on about being a criminal defense attorney. He said, I was a prosecutor for 5 years, and I'm a hard man until I get a little sympathy for you and empathy. And then I'm 100% in your corner, but early on I was telling him about one of my clients who was pretty despicable and just miserable man. And he said, just remember, the whole world hates your client, the prosecutor's trying to put him in jail, and the judge is going to be happy to put him in jail and lock him up for a long time. He goes, you took an oath to defend this man to the best of your ability. His family may have even turned on him. You're it, the one person in the world, and you took an oath to do it. He goes, how can you turn your back on him? You took an oath to God to be there for him. So how can you even sit there and begin to say those things? He goes, do it. Do what you said you would. And he was right. And a quick illustration of that is I had a few years ago gotten appointed to a man, and I'll say this, I had the word written down here, I forget what word did I use? He was detestable. He was a detestable man. I represented him for about a year and a half. We tried his case. He ended up taking a life sentence. We struck the jury, the trial was beginning, and he thought, we're going to roll the dice, we're going to beat this one, looking at life without parole, no chance of parole. He's going to, as the prosecutor said, walked over and he said, last chance, take this deal, I'll offer him life. If he turns it down, he dies in prison. 30 years from now, nobody will care, and his body will remain in prison for eternity. No one will pick him up. My client said, take it to trial. So we did. He underestimated the prosecutor. Went through the jury selection process. We broke for lunch, and my client turned to me and said, oh my God, he's good. I said, he's very good. He goes, can I get that deal? And I said, we'll see. We came back, and the prosecutor said, yeah, he can have the deal. So my client took the life sentence. And then he turned around and he filed a complaint on me and threatened to sue me. But about 6 months later, I got contacted by his son, because his son, who is a nice young man, was joining the service. And his dad was detestable. But I'd gotten to know the son. He was about 17 years old. He graduated from high school, and he stayed in contact. And when the son got in the service, he came by the office, and he showed up in his uniform. And think about that. You're 18. He joined the Marine Corps. And he showed up at my office in his dress blues. And he was so proud. And the only person in his world that he could be proud and show off to was me. And, it's just like, I don't know the kid's name. It didn't matter. It's like the little kids in Sunday school. Hey, Mr. Bry. And it's like, hey, you, But they had to have the recognition. And I'm going to get to the outline in a quick. But here's the one that has changed my life. I got appointed this, at the time, totally despicable young man. His crime was so heinous that we're in federal court. His crime was so heinous that the law provides when he completes his sentence the United States government can petition to have you locked up for the rest of your life. It's a civil commitment for the rest of your life. So you can do 1 to 10 years, but when you're done, you can go away forever. Okay? He was a member of the occult. He hated Christians. He worshiped Satan. He was dark. He was possessed. He was about 19 years old. And his crime was, I learned thing in that case, and I was probably about 50 at the time, going to be 55 now in case anybody's looking for gifts. It'll be about 2 months. I'll give you some ideas. So I get him, and we plead guilty quickly. Each and every trip to jail to meet with him, it's one of those, you wake up and it's like, oh, I got to go see this kid today. This is not good. You know, it's one of those, oh yeah, I'm in his corner. I got to do this. I got to do this. And but it's terrible. And so we plead guilty, and we got about 3 months to go to sentencing in federal court. So he's got an adoptive mom, and I'm talking to her, and we're finding some things out. It's like, why is your adoptive son so messed up? So the story just starts coming out. Well, apparently there's some fetal alcohol syndrome. He was born to an alcoholic mother. He's about 2 or 3, and his mother drowned his sibling, or his little brother, in the toilet. And then she's in a wreck, and he's injured in a wreck, so they take him away from her, and he's raised by his adoptive mom, his aunt. By age 4 or 5, they know there's something terribly wrong with him, and he's probably most of his life he's in group homes and doing some real bad acting out. And that's his life until he's about 16. Then he's put in some really bad homes for real bad behavior. And the one thing that appeals to him is the occult. There's some cemetery here in town, and that's where he goes at night to do his worship that he does. And then he commits this atrocious act. And so he's looking at 5 to 10 years, and then, like I said, it's pretty certain that when he completes the 5 years in federal prison, he'll be, say, 24 to 25 years old, and then he'll serve the rest of his life in federal prison. My guess would be by 50 to 55 he'll die, because there's just, there's no hope for you, and somebody's going to kill him while he's in prison. And my case will be over in 6 months, and that's his life. So here it comes. It's Easter week, and it's Good Friday, and I like to listen to this devotional. It's Wisdom for the Heart, 91.7 at 7:30 in the morning, if you ever get a chance to listen to it. And it's Good Friday. And I'm listening in 91.7, 7:30 in the morning. And I'm listening to it, and it's Pastor Stephen Davey. And he's talking, and he's wrapping it up. And the closing music starts. And it's a beautiful, beautiful summation. And he's talking about the crucifixion and the various interpretations of it, how, the piercing the side so we could be close to the Lord's heart and things like this. And he's doing this. This is emotional time. It's Good Friday, and I'm just getting in there. And just as that happens, my phone rings. And as John pointed out, this boy's mother was one of the people I'd given my cell phone number to. And just as this happens, my phone lights up, and it's her name. And I pick it up, and she just says, Stephen's changed his ways and has dedicated his life to Christ. And he is now witnessing to other people. And so I said, well, great. And I'm thinking, I've had so many jailhouse conversions. I go in there, I've never seen such a transformation in my life. And the reason I knew this one was good was he said, you know what? If they lock me up for the rest of my life, that's perfectly fine, because there's nothing that they can do to hold me, because I'm free. And what was real nice about this one was the prosecutor, who is very stern, was proud for him. The probation officer was thrilled about it. And this young boy went in front of a judge who is a very stern man and good friends with Mr. Alan Brinkley, one of the tougher federal judges we have. And I put this in the package to the judge. I didn't know how far to push this thing. But he stopped and took a break from it and told them how proud he was for the young man. Everybody along the way had seen it, because these people had watched him over the 6 months. And this young guy went off to federal prison, And it was wonderful. And he said it in court. He's like, I don't care how much you give me. There's nothing can change. Here's my old life. I'm new. And the way people had treated him had convinced him that he had a better future. And whether he spent it in prison or on the streets, it was going to be okay. And you know what? He's going to get out in about 2 years. They're not going to do the lifetime thing. And the court system in that case, like I said, the 5 to 7 years that he got, everybody in that case was touched by it. And it was a tremendous outcome. And so while it's a criminal justice system in there, it was a magnificent transformation. And I tell you what, it changed me. And his mom and I still stay in touch. It's been about 5 years now. And it was nice. Like I said, Alan knows the judge. And I haven't seen him do a gentle touch on anybody like that. And we're talking about a heinous crime. So while it's a criminal justice system, there's some wonderful aspects to it because there's a lot of good people in the system. The system, I like to tell people, the law divided into, you got a big chalkboard, it's split right down the middle. There's civil stuff, that's what Alan does, and Joan Marie. Then there's the criminal side, and that's about half it because the court system at the courthouse, you got the criminal courts, and then you got the civil courts. And we eat up about half the court's time. You have two types of crimes. There's felonies, which are the serious ones, and that's why there's special connotation. Felonies, that's where you serve more than a year and a day and up, all the way to the death penalty. Those are crimes of the murder, rape, robbery, burglaries, anything where you're going to serve more than a year and a day. And then misdemeanors are anything less than a year. Felonies, for the most part, you're going to go off to a prison. A misdemeanor, you're going to serve at your local county jail. The county jail is here in this building. State prisons are located throughout the state. The way the courts hear the cases, misdemeanors are generally going to be heard in your district court. So a misdemeanor, there's simpler crimes like a DUI, a theft like a shoplifting, disorderly conduct, resisting arrest. If you commit those in Madison County, you go to Madison County District Court. It's the lower court. If you commit a misdemeanor in the city of Huntsville, then that takes place right here in this courtroom here. So a misdemeanor in the city of Huntsville, this courtroom, a misdemeanor in the county of Madison, over at the Madison County Courthouse. I tell people when you think about what court you go to, just remember the signs, like when you're driving down the highway and it says you've come into Madison County, for the most part, a misdemeanor, the county has the jurisdiction. So you're going to go to the county courthouse. When it says you're in Huntsville City, you're going to go to Huntsville City Court. This is Huntsville City Court. Felonies, any felony in the city of Huntsville or in the county of Madison, all felonies go to the Madison County Courthouse. That's just the way they do. So misdemeanors in the city here, misdemeanors in the county there at the Madison County Courthouse, the high rise. All felonies are up there at the circuit court. The federal court's just a little bit different. They are, federal is different in that they have misdemeanors too. Misdemeanors in federal court are generally going to be crimes that are committed out on Redstone Arsenal. So if you have a misdemeanor on the Arsenal, like a shoplifting out on the Arsenal, you go over to federal court on Holmes, and they have a magistrate for that. If you were to commit a misdemeanor out on Wheeler Refuge or a Little River Canyon, and for some reason, and I'm always shocked at this, people, if you're going to smoke marijuana, and this doesn't look like a group that's prone to smoke a lot of marijuana, but I don't know. I won't put it past you. So, and if you do, my number will be later on the handout. Feel free to call. I put one too many. I'm not a typist. My number's not 11 digits. It's drop one of the zeros. Give me a call. But people love to go to a federal refuge like Wheeler or Little River Canyon and smoke marijuana. It's a lot worse if you go to a federal installation and smoke marijuana. If you must smoke your marijuana, I'd say do it in your house, and don't go into the city of Huntsville, the county of Madison, or for sure don't go onto a federal installation like Little River Canyon or Redstone Arsenal or Wheeler Refuge, because it's they're pretty tough on you. They've got, man, those federal guys, they walk through the parking lots like Little River Canyon. I love it. They will walk through the parking lot and they can look in your car and they can see one flake of marijuana on the floor of your car. And my wife's immaculate, but there's more than one flake of stuff, not marijuana, in her van. There's no weed, not anymore. But there's some stuff on the floor of our cars, but they can spot the weed. They're good. And anyway, but yeah, they do it. And the one that always gets me is this, the Native American land. Does anybody know the closest Indian land here? As soon as you go over the bridge into Decatur, on the right, the boat stuff, I had a case over there, and it was fascinating. There's arrowheads right there, and it's marked Native American land, no digging. And you can pick, and be careful, I'm not giving legal advice here, but you can pick an arrowhead off the ground there where it's marked, but you can't dig them up. And they said my client had dug some arrowheads out of the ground, and our defense was, no, I just flipped them with a stick. And the charge was he dug, not flipped. And they said, therefore, he was digging, and we said, no, we were lifting. And the charge was, he was looking at jail time because he got like 6 of them. And it was going to be, I think he was looking at probably close to a year. And it wasn't as much the jail time and the fines, but you have to pay the cost of rehabilitation, and it was going to be over $100,000 because the land has to be completely restored. You pay for all the experts that come in that evaluate everything, and every single stone has to be replaced, and they said they had driven a vehicle out there, but it was over $100,000, and we got the case thrown out, fortunately. But so if you go out there and move a bunch of rocks around and all that, they're going to pay for, I would say, easy $50,000 to $100,000 if you get caught doing that. The guy before us he got like 1.5 years in jail for taking a bunch of arrowheads. So be unbelievably careful. You got to really know what you're doing when you go arrowhead hunting on federal land. So anyways, federal court, they do misdemeanors. I do a lot of federal cases. Felonies in federal court, there's a thing called the guidelines, and you do not want to mess with federal law. State courts, interesting, but I think Madison County does about 13,000 criminal cases a year. Federal court does a fraction of that, and it's because they're slow and methodical, but the sentences in federal court are just crushing compared to state court. They have fewer prosecutors, a fraction of them, but the sentences they hand out, the last one, the big one I heard was, I think, close to 3,000 years. Somebody got 3,000 years over in the Florence area for some improper acts. So federal court's just a real serious area, and they don't hesitate to house you for all your life, whereas state, our jails are overcrowded, so they're much more lenient. The steps in a felony case, most cases start with an arrest. The way they do it, I had a hearing today, a suppression hearing on a case. They pulled my client over. She was in the car. They saw some scales in there. They got her out, patted her down, and they arrested her. That's a pretty typical case. Another way they could have done it was they got her out. They claimed they found some marijuana on her. They could have waited, gone back, got a warrant, and then just arrested her whenever they wanted. Another way a case can start is this lady here could go down and swear out a complaint against you. And then you go to the magistrate and say, this person struck me, and then an officer will come out and arrest you. And that's how a case can start. There's many ways. At that point, once you're arrested, a bail will be set, and the bail can be, there's it's Rule 7 of the Alabama Rules of Judicial Administration. They have suggested ranges. Most of the time they're followed. You can either have a bond set. They can say you're entitled to pretrial release. You can pay the bond. You can get a bond company. They usually require about 10%. If you pay them that, you're going to have to put up some collateral, or you can pay cash. If you're fortunate enough, when you pay a bonding company, that money's gone. You give them the 10%. They keep the money. They bond you out. They're on the hook. You're not. Well, you're on the hook because of your collateral. If you can afford it, your best bet would be to put up cash. That way, when you show up to court and your case is resolved, you get your money back, hopefully. The next step in the case would be the felony examination. That's just where you go to court. That's usually going to be a week or two after you've been bonded out. You show up to court, and the judge will say, do you have an attorney? You're going to retain an attorney, which is a good thing. You come pay somebody like me, and all your problems will disappear. It's a good thing. Or if you don't have one, they'll say, if you can't afford one, we'll appoint one to you. The biggest confusing thing in the world is that you may be entitled to an appointed attorney, which means United States Constitution. Gideon's Trumpet, anyone remember Gideon's Trumpet, the movie, the book? Great movie. I think Henry Fonda, fantastic movie. Pensacola, Florida, busted into the vending machines at the washateria, couldn't afford an attorney. Abe Fortas represents them. Abe Fortas goes to the U.S. Supreme Court and all that. So he got an appointed attorney. You get an appointed attorney to help you through the system. You don't get a free attorney, you get an appointed attorney. When your case is resolved, you pay the state back. Yep. You get an appointed attorney to walk you through the system. If you win, great. You don't pay them back. If you lose, or even in most of the cases, if the case gets dismissed, the first thing the good judges will say is, your case is dismissed upon payment of court costs to include paying back the fees of your court-appointed attorneys. So clients, I try to be square and upfront with my clients. I do appointed work. You have to. I mean, number one, it's part of your duty, I think, as an attorney, is representing the people of your community. Number two, I like money. I got a wife. I got 3 children, one in college. She's at Sanford, not N.M. Sanford. Sanford's expensive. I got 2 kids at Whitesburg Christian. That's not cheap either. I like steady cash, and appointed work pays okay. It's not great. I tell my clients, I'm your appointed attorney. Every time you call me, I stop what I'm doing, I pull your file, I try and answer your questions. I'm billing you. Get your questions together, call me. I'm going to answer your questions. You call me 5 times a day, I'm billing you 5 times a day. Unless I win your case completely with a not guilty, you're going to be paying that back. And they love calling me, and I love billing them. And I love getting paid, and babies need to go to school, and I need to get them out from underneath the house so Mama can clean the van. So anyways, so I probably have 75, maybe no, not anymore, maybe 50 to 75 appointed clients at any one time. And I got plenty of work, and I don't need them calling me. You can imagine if they all call a couple times a week, you're just returning calls. I mean, you're not getting work done. And that's why I try and tell them, and the same thing if you know anybody that's got a retained attorney, same thing. I mean, time on the phone's wasted time. Attorneys need to work. After the felony exam, the next step is the preliminary hearing. This is there probable cause that a crime has been committed? The state has the burden. This burden is extremely low. In Madison County, the judges always apply the law and apply it perfectly. And if they feel like there's probable cause, they're going to grant it. We, the defense, we use it as a kind of a way to feel out the case a little bit and try and get a little bit of discovery, see a little bit about the case. I got a good one last week. Client told me the facts and pretty much told me everything except for the one fact about he confessed. It's like, it's always fun. You're going along and it's like, yep, so this happened, and the cop said, oh, then he confessed. And it's like, okay, I knew that, and you get good at it. I mean, 23 years, nobody knew that my client hadn't told me that. Like I said, it's fun. Sometimes clients forget things and they forget to tell you that. So it's a poker game sometimes. The rule is fun. The rule says, normally the defendant never takes the stand. I've got a case, I think it's come up in a week, and I'm going to put my client on a stand. Sweet little country girl, had no idea she was taken in and that she was being used by this guy. And he got her to cash a check. She took it. And I'll tell you this, I'll let you all be the judge of it. Normally, this fraudulent check business, clients are a hoot. It is common practice in the city of Huntsville, if somebody gives you a check to go to the bank, they'll take a $1,000 check and I'll pay you $500 to go to a bank and cash this check. If you take my $1,000 check, I'll give you $500. That sound like a fair deal?
If I didn't watch the news, I might think it was.
Yeah. And I tell my clients, you know what? If a judge hears that, there's probable cause that you're in on it. You don't get $500 for cash a check. I'll give you $10 to cash a $1,000 check. That's what you get. But this little girl, she got zero. She went to her bank, she cashed, say, a $500 check, and you know what she got out of it? She lost $500 because they took $500 out of her account. She got nothing. And it was a coworker. She just took a coworker to a bank, and she'd worked with him for months. They did it during lunch, and she lost $500 for cashing this guy's check. I'm going to put her on the stand, and I think the judge will say, when she tells them that, I think we got a chance the case will be thrown out. And of course, if before she takes the stand, if the investigator says, but she told me that she knew about it, she won't take the stand. But normally I don't. It's the rule is you never put your client on the stand. If the judge finds there's probable cause, the case goes to the grand jury. If the judge says no probable cause, but I've really made the DA mad, then we got problems. Because the judge says case dismissed. Well, the DA is going to say, well, you made me mad. So the DA will take that case straight to the grand jury and they will indict your client. And your client will then get arrested again and have to bond out again. And so 9 times out of 10, if I can get a case thrown out at the preliminary hearing, I don't. Because, for instance, I was talking to a woman today, and she got arrested on a trafficking case, trafficking cocaine, and her bond was $500,000. So she paid a bondsman probably $5,000, and she was promised to pay him. Her bond was $500,000, so she has to pay the bondsman $50,000. So she put $5,000 down. She's going to pay him like $5,000 a month for 10 months. At the 3rd month, we got the case thrown out. And they were mad. If they indict her later on, she owes that bondsman another $50,000. And they haven't come back and re-indicted her. But we took a big gamble. She needed to. She needed to get back to work. And she couldn't work with a charge on her. And it's been about a year now, and they never re-indicted her. But if they did, she was in big trouble. And here's the scary part. She gets arrested, $500,000 bond. So she pays $5,000 down, $5,000, $5,000. I get the case thrown out. She still owes that $50,000. She signed a contract. Just because she got the case thrown out doesn't mean that contractual obligation goes away. Yeah, I don't know if the bonding company made her pay it or not, but that isn't, if things go great, I'm off the hook. That bonding company was on the hook for $500,000. It's up to them. If they want to cut her a break, they can. But it's a rough world out there, and bonding companies aren't into this to make friends. So the if the case is bound over, that's the term to go to the grand jury. They go to the grand jury, secrecy. Your client technically can go in there. I've never had a client ever go to the grand jury. If they go, I can't be there with them. I don't let my client go talk to the cops usually. I never let anybody go to a grand jury. My answer is you can't get hurt if you don't talk. So, they get indicted. It's called the true bill if you're indicted, a no bill if you're not. Next, you get indicted, and so after that, and we're talking from the date of the arrest, grand jury is probably about 6 months to a year. Within approximately about a year to 18 months, you're coming up on trial in Madison County. That's when we start doing our motions. First one is going to be my motion for discovery. That's where I say, give me all your, it's called Rule 16 under the Alabama Rules of Criminal Evidence. That's where I get the discovery, things like any statement my client may have made, any statements from the co-defendants, any evidence the state's going to rely on to go to trial. Brady motion is it's Brady versus Maryland. That would be any evidence that shows my client's exculpatory. They have an obligation to give that one up. It's interesting. That's the defense attorneys. That's always a quandary. I know my theory of the case, and if my theory of the case is you're my client, you didn't do it because you did it. And that's my theory of the case. So the DA may be looking at the evidence, and there's some evidence that you were at the house where the murder took place. Well, if they don't know that my theory is you did it, then they may see that evidence and not give it to me, that you were there. And I don't want to tip my hand too much, so I don't know that they got evidence that you were there. And so that's always a difficult thing, is they have it. I don't see it. I don't know they've got it. And so I've got to try and get things that I don't know exist sometimes without showing my hand too much. So there's always a tension there, trying to get things without showing them too much of what your theory of the case is. Motion to suppress is the famous things like Miranda. Did they read your client his Miranda rights? And if they didn't, I'm trying to suppress the statements. My favorite case of all times from law school is Wong Song. There's a bunch of guys, and they violated their rights. And so therefore, if you violate their rights here, and later on you find out a bunch of evidence. There's Wong Song and Blackie Toy and all these different characters. And the idea is if I violate your rights here and then like a week later I get all this other evidence from that, you can't use that. It's called fruits of the poisonous tree. Those go out too. So you're always looking for ways to suppress evidence. So again, one thing you're looking to suppress would be statements made by people. The other one is suppress search and seizure. That's what I had today. They pulled my client over. Guy's driving. He had scales in the car. They got him out. They're arresting him for having paraphernalia. And my client says, can I use the restroom? He said, nope, you got to wait there. 20 minutes later, a female cop gets up. It's a woman. They pat her down to find drugs on her. And I said, you had no basis to search her. I thought I was right. Judge said I was wrong, so he didn't suppress our motion. We'll take that to the Alabama Supreme Court. This is just me on it. The law says the United States Constitution protects you from unreasonable searches and seizures. And it's a burden on the United States government. The minute you raise that, they have the burden to prove that they complied with the law. Where I'm sitting from, it always seems like I got to prove they did something wrong, and it's not them. It's not. Like I said, it's perspective. It's us, and I'll say this. My estimation, I don't know what my percentage of winning cases is, but it's not great, but it's okay. And for a defense attorney, I think if we win 10, 20% of our cases, we're doing fantastic. Most of the time, for us, winning is getting a good sentence a lot of times. And when I was a prosecutor 5 years, my old adage was, if they weren't guilty, we wouldn't have arrested them. And I think that's the way a lot of people in the system look at it. And so, like I said, I had a winning streak at one point. I won 4 jury trials in 2 months. And man, I was on a roll. I should have walked away right then, George Costanza style. But it's hard. I mean, because they said the system, when they walk out there and the jury sits down, and sees the charge against your client, you know, a lot of times, we'll get to that in a minute, it's not easy. As far as the searches and seizures, there's a number of exceptions to the way, you know, they can do things. For instance, you have a right to be free from unreasonable searches and seizures. However, in the case I had today, I wasn't representing the guy, but the cop said his tag was expired. I walked up to the car and I looked in, and he had an electronic scale. And it's funny, I love progress. When you hear he had a scale in his front seat, how many people think like postage scale, you know, the kind with a spring and everything like that? They look like smartphones. You know, they're the little electronic ones. And the guy in this case said, I deal in gold. That's what it's for. You know, I'm weighing precious metals right here in my car. The cop's like, there was marijuana all over that little precious gold scale he had on there. That's, you know, that's plain view. So the cop walked up. He didn't need a search warrant. He didn't, you know, right in plain view, there's this scale with marijuana on it. So that gave the cop the authority to arrest him or search the car. Once he arrested him, the next exception to unlawful search or seizure would be inventory. Well, I've arrested him. I've got a car. Now I can inventory the car. That gives him the right to go into the car. Next one would be consent. If he had asked my client, do you mind if I search your car? At least 50% of the time, they say, sure, go ahead. It's amazing. It's just like, you got drugs in there. Why are you consenting? Just say no. Wasn't it the old drug thing? Just say no. The other one is incident to lawful arrest. He arrested the guy for the paraphernalia, and it's like, okay, I've arrested you. Now I can search, at least in your wingspan, stop and frisk. This is the one that gets me. You're walking down the street, and if the cop has some articulable reason he wants to question you, he can basically stop you and pat you down. Give me your name, and boom, I'm going to just pat you down just because I'm talking to you. Automobiles have a propensity to be moving and mobile and can just drive away. So give me a second here. I just got to look around a little bit. And since I'm talking now, I have some basis to stop you. I'm going to make sure within your wingspan, I'm going to make sure there's no weapons. And guess what's within your wingspan usually? Your dope, because when you see the blue lights, that's where your wingspan's where you're going to be able to reach and put your dope. So it's one of those rules, the exceptions just eat up. And here's one. I got this one going up to the Court of Appeals now, exigent circumstances. The guy, cops knock on the door, he opens up the door, and they said, can we come in and search? He said, absolutely not. And he shut the door behind him. So they said, fine. They cuffed him, pulled him out in the hall in his underwear, shorts and no shirt in February. And they went in there. Exigent circumstances. Somebody might be in there getting rid of the dope. And they went in. And the judge said, exigent circumstances. And they found $13,000 and 10 pounds of weed. And but I think it's going to get busted on appeal because it was like there was nobody in there, so they couldn't destroy it, and you could have got a search warrant. I mean, you had him handcuffed in the hall. The idea would be go get a search warrant, and it's like if there's nobody in there, what was the exigent circumstance? They said somebody might be in there. It's like, but you did a walkthrough and there wasn't anybody in there, so what was the exigent circumstances? And they said, well, there could have been somebody. It's like, but there wasn't. So anyways. So you do those pretrial motions, then you got your arraignment. That's just the formal reading. Most of the time, that's when you get in here. In Madison County, a lot of times, they'll say, here's the formal charge. You're saying that. The jury's coming down the steps. They put the jury in the box. You do your voir dire, which is just your formal question of the jury. You're starting to, at that point, starting to develop your questions on them. You want them to, start to develop your theme and theory. Then you strike them. There's two ways you strike a juror. One is for cause, and the other one is just preemptory. It's just like you've got X number. You got to get 12 jurors, usually 2 alternates. So if there's 30 of them, and you got to get it down to 12, then that's like 9. You get 9 strikes the person. I think that's the math. Opening statements would be next, and my key on that one is I try not to make too big a promise. I like to keep it within reason. You don't want, last thing you want to do is get up there and promise things you can't deliver. It just makes you look horrible. Credibility is everything in a trial. The state goes first. They get to put on their case, and it's interesting. You just never know on a case what's going to happen. It's horribly tense on the way building it up, and then it starts, the butterflies just go away, and things just fall apart. The people get up there, and what I find is one of the best ones I ever had was right here in this courtroom. It was a tiny, tiny case, but it was an unbelievable lesson. My girl was charged with striking a girl at a McDonald's parking lot on 72. And it was the employee of the McDonald's and the manager of the McDonald's. And I interviewed the manager right out there. And it was two like 18, 19-year-old girls, and the manager was, say, a 30, 35-year-old woman. And I think everybody here would do the same thing. You look to the 35-year-old and you say, okay, between us, tell me what happened. And she goes, I'm walking in with my employee, and your client just walked up and just cold-cocked her. I said, did you see the whole thing? I did. And did your employee do anything to provoke the situation? Absolutely not. I saw the whole thing. She just walked up and she punched her. No provocation, nothing. It's like, well, this is not good. It's like, okay. My client swears up and down. And I said, okay, well, you paid me. Let's try this thing. And we were sitting there, and it was fascinating. And the victim, she gets on the stand, and she goes, I was just walking. She did that. And we put the manager on the stand. And I asked her, I put her on. And I said, tell me what happened. She goes, well, we were walking in and she hit her. I said, did you see the whole thing? She goes, yep. And I said, did you have a clear view? And she goes, well, not really. And I said, really? I said, so where was she compared? She goes, well, my employee was over here and your girl kind of came out of the side. I said, well, did you see who threw the first punch? She goes, not really. I said, is it possible that your employee, swung on her first? She goes, maybe, I don't know. And it was just like, you know what? And I promise you this to this day, and I still believe the same thing. Out in the hall is one thing, but when they sit in here and take an oath, it makes it hard to lie. And I've seen that over and over in cases. And people do. I mean, it makes a difference. And that's why, and I tell people, you just never know what people are going to say on the stand. And it's fun. That's what makes it fun. So the state presents its case, then they close, and the law says that we have to make a motion for a judgment acquittal when they close. And it's one of those nuances that if you don't do it, hopefully, by golly, you better win the case. The defense, if you don't win, you just committed malpractice, because a requirement for the appeal is if I don't make that motion for judgment acquittal, all's lost. And you watch people do cases. I saw in federal court the judge one time, I started to forget, and the judge was like, Mr. Clark? I'm like, oh, that's right, Judge. That was a good judge. He was protecting me. But then after the state rests, we get to put on our case, if any. There's a wonderful axiom, if all else is lost, go ahead and put your defendant on the stand. And I'm thinking, I've done approximately 150 jury trials in 20-something years. I'm thinking maybe 5 to 10 times I've had a defendant take the stand. And I'm a big believer in make the government prove their case. And if they can't, in the times I've had my client take the stand, very few times have they helped the case. Most of the time it's hurt the case, and we would have won it without them. Yes, sir?
If your client wants to take the stand, can you stop them?
No, sir. The question is, if my client wants to take the stand, can I? And the answer is no. And I love the question, because here's my rule. I got I've had some wonderful teachers, and there are 3 decisions that are made by the client. I love being in charge. Every decision is mine. They're all, every decision is tactical, and every decision is mine. I'm the professional. You get 3 decisions as my client. Do you want to plead guilty or not? Guilty or not guilty? Do you want a judge or a jury? And do you want to testify or not? And my clients, I have a sheet of paper, and you circle it. Guilty, not guilty, judge or jury. When the state rests, I turn to you, and only then, at that point, because that's the only time we know, then I turn to you, and I have that form, and you initial, yes, I want to testify, no, I don't want to testify. I'll have an explanation down there saying, at this point, boy, we're in big, big trouble. Even then, I still suggest you don't do it, but it's your choice. And I have that, and what I do is I have a notepad, the trial notepad, and it's the cardboard usually, the last sheet just before the cardboard. I can't lose that notepad, and and I love it when they come back and try and start stuff on that, because when things go bad, I'm always the last line of their defenses going after me, but yeah, don't even try it.
The reason I asked is 15 years or so ago, I was on a jury, and the prosecution did not prove the case.
Sure.
If the defense would have just said, we rest, the guy would have walked.
Sure.
Defendant got up and answered all the questions.
Sure. Yeah. That's why you don't let them talk usually. Never give them anything. Like I said, it's rare to put them on. Afterwards, then we get to argue, and argument's not evidence, but I can fool a jury pretty good with my arguing, and it's great fun. The most destructive argument I ever had thrown against me was DA Bob Becker. We had a great case, and Bob got up, and he just said, I'm not going to say much because I think Clark's a weasel. And he goes, I'm going to let him do it, and then I'm just going to come back and deflate his whole argument. It's like, Bob. So finally, after we argue, they get to go last because I always say, because they need the extra help, but no, the law just says they get 2 shots. Then the judge will give them the instructions, and it's funny. They like that because it takes away all the energy that we get, because arguments are great. Then they want to bring everybody down, so they give them the horrible instructions, but they're key. The instructions are key because it gives everybody a chance to file appeals, because instructions always get full of mistakes. Then you get the deliberations. Then they come back with their verdict, and if you're convicted, you have a right to a pre-sentence report. After you're sentenced, you got to file all the important motions within 30 days. Then you got 42 days from the actual sentence to do your appeal. The fun stuff is, like I said, the federal case that I won with the Kittens. They talk about hoodwinking a jury. My client was charged with shooting someone at point blank, and they had the victim and 3 eyewitnesses to it. And we convinced the jury that it didn't not that it didn't take place, but the state hadn't proved its case. And the key was this: the victim said he walked up and shot me. Well, the government's problem was the 3 eyewitnesses told completely different versions what happened. The victim admitted he was a drug dealer there, just dealing drugs. And here's where the jury, I had a fantastic jury. And what they said was, the cop got up there and said, well, your client stood right there, and I found the shell casing right where the victim got shot. And I really dug him in on his statement. And then I said, oh, by the way, you said you found the shell casing where my client shot with his gun right there, and that's what your report says, and that's all under oath, right? Yep. I said, now who found the shell casing? He goes, I did. I said, did you really? He said, yeah. I said, so it wasn't the victim's brother that found it? And he said, oh yeah, that's right. I said, and he told you he found it there. You don't know that he found it there. He could have found it anywhere. He goes, well, yeah, I guess. I said, so your report was a lie? He said, yeah. And then I said, and the guy who had the gun, it's possible he actually shot the gun. He's like, who knows? And I tell you what, the jury, they were furious. And I got up and argued. I said, you know what? You may think my guy did it, and I never said he may have done it, but you may think that, but you took an oath to uphold the Constitution, and you said, beyond a reasonable doubt, prove every allegation. And you know what we know? We know the cop lied, the 3 eyewitnesses couldn't get their stories even close to being straight, and the victim said something happened, and he's a admitted drug dealer. And you know what? You're going to break your oath if you convict my client. And they were furious. And you know, what's worse, convicting my guy and breaking your oath, or saying not guilty and dismissing all this incredible testimony? And they did. And I just got to say one thing. I had a client, it was completely innocent. They found some drug, a pill bottle in his bedroom, and it was his roommate's drugs. He was the target of the investigation, and he put some drugs in my client's. We took a polygraph. We were willing to take a polygraph. We asked them to fingerprint the bottle, and they wouldn't do anything. And you talk about an innocent kid. His dad was a retired narcotics officer. This kid was so innocent, and it was horrible. And for 3 days, we tried that case. He was looking at trafficking and morphine. It was pills. Nicest kid in the world. And this was 2 years ago. This was part of those 4 in a row that I won, February of 2013. And we tried that case for 3 days, and the state refused to budge. They did their job. They thought he was guilty. I thought he was innocent. I knew he was innocent in my heart. And we tried it, and that jury came back, and they said not guilty. And I tell you what, the lead juror came over to my client's father and hugged him. And they said, we knew it was going to be a good day for you. And last week, I got this card in the mail. And I'm just going to read you part of the note, because I just need you to hear this. I'll read even the good part. Your professionalism and tenacity defending my son for myself and my family, our faith has been refreshed. He's teaching and getting married to a very special young lady coming up. May God bless you. Many thanks once again. And I tell you what, you know, it's a wonderful system, and I'm proud to be a member of it. Thank you all.